didn't want to talk, except that to bring to the attention of the court that the public participation was done on Saturday, which is contrary to Article 37. Number two, the public participation was supposed to be done at the polling station level. Deputy presidents and presidents tallying ends at the polling station. Third, the notice of the constituency public participation. The court gave the orders at around 4:30. There was no notice sufficient for people in the villages to go to the constituencies. Therefore, that completely made people not to participate because they were not aware. The notice that was initially given was a notice at the constituency level. Can that be the position that this court will uphold? I beg that the court extends the grant of the consultative orders. Thank you very much, my lord. My lord, thank you.
Your Lordship and my lady, my name is Akimpa. For the third petitioner, we'll be sharing time with your colleague with our voters.
Is number 2. So my lord, breaking for an hour or so is a very appropriate thing to do. And I ask the court.
If you want to break by some order, we want to complete the applicant's case. Then you can proceed.
Okay. We will persevere.
You have enough time. How much time do you want?
I need 5 minutes, but I would appreciate it if you don't know because I have dyslexia, so it will make me start rapping instead of delivering
So,
my
talk about
submissions.
please.
Yes, my lord.
Your name?
My name is Wanjiru Mwangi. I am the 12th petitioner in Consolidated 5E65 of 2024. And together with the 11th petitioner, Dr. Goslo, we asked to be enjoined as interested parties in this matter. My lord, unlike most people in this room, I want to disclose that I have a learning disability or ability called dyslexia, so I asked for time, not to rush me so I can articulate myself properly. My lords and my lady, I would like to ask this court to deem myself and Dr. Iboso being properly in record, for the sole reason that in other courtrooms we have made submissions and been told that we are not properly in record, and would like our submissions to remain on the record. My lords and my lady, I only have 5 questions today that I want to task to the judiciary and to the members of, and to the public and to everybody else. Question number 1, the judiciary on trial. My lords and my lady, the only questions you're on trial for in the eyes of the public is a simple one. Is the judiciary truly impervious to the reach of the corrupt and the political class, locally and internationally? If the answer is yes, the Bill of Rights must be respected and upheld. For this, I rely on Article 159(2), justice shall be done to all, irrespective of status. Read together with Article 27(2), which states, equality includes the full and equal enjoyment of all rights and fundamental freedoms. Question number 2, the Constitution on trial. My lords and my lady, the second question the public will be asking is when our Constitution is on trial, because it is no doubt on trial, will the judiciary bend to the insurmountable political pressure over jurisprudence, the Constitution, and the rule of law prevail in such adversity? If the answer is yes, then the conservative orders must be stayed. For this, I rely on Article 27. Every person is equal before the law and has the right to equal protection and equal benefits of the law. Question number 3, the laws on trial. My lords and my lady, the third question that is important to the public is that once a court clearly states that a right is absolute, as this court did on the 23rd of October 2024, then the public will be interested to see and know if the court will uphold its own directions. If the answer is yes, then this court must respect and uphold its own directives. and guarantee all the petitioners, especially those who prayed for conservative or injunctive orders whose applications have not been heard and determined, including us laymen, the rights to a fair trial as specified in Article 50, which reads, every person has the right to have any dispute that can be resolved by the application of a law decided in a fair and public hearing before a court. Read together with Article 27.3, women and men have the right to equal treatment, including the rights to equal opportunities in political, economic, and cultural spheres. President is on trial. The inadvertent question we as a society have to ask ourselves is a moral one. Does the court have any real authority to successfully reverse the impeachment and reinstate Rigathi Gachagua? Based on the truth we know, the truths we have been shown, and the truths we are constantly reminded of by the political pandemic we have been suffering, what confidence does the public have that if the conservation orders are lifted, the court will have any real authority to successfully reverse those orders? Then, under the same assumption, the ascension of Professor Kindiki will succeed after that in a manner of what we expect to be ours, despite the numerous legal ambiguous queries about the gazette notices in the middle of the night and a lack of IBC commissioners to vet or validate the public participation in a manner. The answer is no. The court will be unenforceable, will be unable to enforce on the office of the president as enshrined in the Constitution and affirmed by the Supreme Court. The court does not have jurisdiction to force Kindiki, if he's sworn in, to recuse him, to impeach himself. That is the real conundrum in a nutshell, and is as simple as the deputy president assumed office. And if the president is unwell, does the judiciary in fact find the impeachment? And if the, sorry, let me just say it again, please. The real conundrum in a nutshell is as simple as this. If the deputy president assumed office, and then the president is unwell, and the judiciary does in fact find the impeachment process was flawed from the National Assembly due to violations of the Constitution, what then? Will the acting president impeach himself as a deputy president? Can he is it even possible, and who will enforce those orders? The conservation orders cannot be lifted if they will be rendered a nullity, null and void. For this, I submit Article 27. The state shall not discriminate directly or indirectly against any person on any ground, including race, sex, pregnancy, marital status, health status, ethnic or social origin, color, age, disability, region, conscience, belief, culture, dress, language, or birth. Question number 5, and my final question today, is our system is on trial. My lords and my lady, on this final note of mine, I humbly stand before you as a layperson with arguably what I hope to be some of the best legal minds in this country. As our nation is once again at the precipice of a revolution, as the spirit of our nation is reawakening, I submit to you one of the most progressive documents in the modern world, our Constitution, a document which guarantees even terrorists due process, whose preamble starts with, we, the people of Kenya, and ends with, adopt, enact, and give this Constitution to ourselves and to future generations. It is time to take our place. It is time for the Constitution to prevail. It is time to no longer allow political urgency to override judicial processes. Our country will still be intact in 30 days, and it will still be intact in 60 days without a deputy president. Our Constitution went so far to envision not only the vacancy of the deputy president, it planned for the eventuality of both the president's office and the deputy's office being vacant. Kenya will be fine. We, the people, will be fine. Let the natural cause of justice prevail. It is what we envisioned, and it is what we envisioned for an independent judiciary. Thank you, my lords and my lady. I submit.
Thank you.
To inform the court that what is on trial is a Bill of Rights. Article 38 of the Constitution provides that a person has a right to vie and be elected for office, and if elected, has a right to hold that office. I know that is one of the things that is on trial, but I will ignore that for now. What is at stake, because a conservatory order is supposed to preserve the substratum, is the right to a fair trial. My lord, the components of a fair trial include the tribunal that is independent. It includes the process and the outcome. My lord, the outcome includes the remedies that are available by law to the individuals before the court. one of the remedies, the material remedies that the parties before this court are seeking is reinstatement of Deputy President Rigathi Gachagua to office. Therefore, and I will demonstrate when I talk about the Wajir case at the end, that once a new person assumes that office, that remedy is completely taken off the table. And that means these conservatory orders are actually at the heart of a fair trial. And a fair trial is among the rights under our constitution that cannot be limited. It is not that a fair trial is absolutely not limitable, but that the state through its action or any person through their deliberate action cannot limit the right to a fair trial. Why do I say this? During a trial, the witnesses may die naturally. COVID may happen and cases are delayed naturally. That is extrinsic and it may affect a fair trial. But the court must never do anything deliberately that would impede a fair trial or that would be imputed as limiting the right to a fair trial. So, my Lord, by lifting this conservatory order, you will be actually limiting the rights of the petitioners to a fair trial by taking away a very material remedy to the remedies that are available to them. I'd like to talk about what is the place of the Bill of Rights under our Constitution and the concept of public interest, because it has come up very much. Now, our Bill of Rights under our Constitution is very fundamental. The Bill of Rights, the chapter on the Bill of Rights, is the only chapter under our Constitution that has its own doctrine of interpretation. And the Bill of Rights is enjoyed individually as per Article 19, is by individuals. It is actually antithetical to the concept of human rights and individual human rights to say that the Bill of Rights will be enjoyed at the behest of a public interest. They are actually specified there expressly, especially to be enjoyed in spite of the public interest. So I feel like the argument that the public interest should be balanced against the Bill of Rights is antithetical to the very concept of the Bill of Rights. The limitations of the Bill of Rights is captured in Article 24, and I would have read the entire article for us to see. But what the provisions that it provides is that the Bill of Rights will not be limited except by law, and then only in a manner that is reasonable and justifiable. My Lord, the public interest that has been propounded by at least the response by the Attorney General or the application that by the Attorney General did not disclose the legal basis of that public interest. In fact, it was just general. And it brings me to the question. It reminds me, in 1945, the Supreme Court of the United States was faced with a case about the Anti-Obscenities Act or Anti-Pornography Act. And Justice Stewart, unable to define what pornography is, in his concurring opinion, wrote, "You will know it when you see it." My Lord, that is the kind of public interest that the Attorney General is asking us to use to balance against the Bill of Rights. A public interest that we cannot really tell what it is. My Lord, the public interest that should be able to limit the Bill of Rights must be founded in law. There must be a legal basis for which you're saying this is a public interest. Whatever the Attorney General has propounded, in fact, has not even specified. It must not be vague. It must be very specific so that we can assess its reasonability and whether it can actually be justiciable or it's justified within a democratic society. My Lord, I saw in the response by the National Assembly, the public interest has been a bit defined and has been stated as the fact that we do not have an IEBC. My Lord, that is not a legal question. The other issue was that we cannot stay without a deputy president. My Lord, as had been propounded earlier, kindly allow me 2 minutes. As has been propounded earlier, my Lord, the Constitution allows us not to have a deputy president for at least 60 days, in fact 74 days. So we don't yet have a legal crisis as we speak. We may have a political crisis, but it's not a legal crisis. The absence of an IBC is a political crisis. A political crisis that cannot be brought before the High Court, a court of human rights, as for that to be balanced against human rights. My Lord, the political arms of government are the ones best placed to deal with a political crisis. And tomorrow they can appoint an IEBC if really there's a political crisis. Finally, my Lord, I would like to bring attention to 3 cases by the Supreme Court. The Munya case, Martha Karua case, and Speaker Mate case. because they kind of explained how conservatory orders ought to be interpreted. And my lord, what I read from those cases is that a court order through a conservatory order cannot overthrow the constitutional values and constitutional imperatives. A conservatory order by the court fetters discretion, constitutional or statutory discretion, never constitutional obligation. And so, my lord, in the context of this conservatory order, the conservatory order cannot be interpreted in a manner as to freeze time. Because one of the things that is considered by all parties in this case is that an impeachment did happen. And it's presumed to have happened lawfully until this court finds that it did not happen lawfully. By that, the Constitution is very express that the office will fall vacant. And so that one, however much a court attempts, it cannot constrain an edict of an imperative of the Constitution. So the office is vacant as we speak. However, time started running, and the president had 14 days, a discretion of 14 days. The court order can fetter that discretion, and where it seems to the court that the discretion was abused and rushed in order so that you can avoid the rule of law and whatnot, the court can make the conservatory order to be deemed as if the action was done as if that abuse was not there. So that the president still had the 14 days, and so the time is counting. Parliament will still have 60 days. Now, at the end of the 74th day, this court's conservatory order, however much it tries, it cannot extend beyond that. Finally, my lord, I want to talk about the Wazir case because nobody has talked about it, and it was part of the Attorney General's application and response. The Wazir case relates to a governor who was impeached. The deputy governor assumed office and then even nominated a new deputy governor, and then later on, the High Court found the impeachment to have been unlawful and reinstated the governor back to office. My lord, there is a distinction, both a constitutional distinction and even a procedural distinction in the two cases. In the Wajir case, the court had issued a conservatory order against the assumption of office, which was defied. But aside from that, because that still is arguable as to whether a conservatory order can do that, there is the question of part of the rule of law and a fair trial is the enforcement, the enforceability of a court order. Now, a court order may be enforced against the deputy governor or the governor of a county. But as per our constitution and as per the holding of BBI, in the BBI case, the presidency is absolutely immune. No amount of court order will be issued that will be able to be enforced against it. Because who will enforce the court order declaring the office of president vacant? My lord, it's the political arms of government that can deal with that, and that might be one of the issues that are political questions that the court cannot really address. So, my lord, as far as the office of the deputy president is concerned, such an order cannot come from this court. We cannot allow the conservatory order to be lifted, and then we imagine that we will be able to enforce an order removing Professor Kindiki from office. My lord, thank you very much. I'd like to ask my co-petitioner.
May I praise your lordship? I wish to make an application under Article 57 of the Constitution. All the members of the fire. The owner is now too certain. Some of us have to eat at certain intervals. And I'm mindful of the court. You have been sitting all the time, you must be now very tired. Say that I've done the doing that.
Those who are Lord, I would like to support the request, very polite request of Dr. Hamino. Dr. Hamino is the #1 longest serving member in the bar.